Hello, my name's Nick Barratt, and this is the third of 3 short films looking at English equity records. In the first film, I explained how many courts were in existence and when they operated. In the second, I looked at the process by which litigants could bring cases into those courts. Here, I want to pick up and look at some of the evidence and other material you might find if you go looking for ancestors in the equity courts. So a quick recap. An ancestor might have brought a complaint into, let's say, the Court of Chancery, setting out the reasons why they felt they had been wronged. They would have named any defendant or defendants, and the defendants would have had to then bring an answer, setting out why the case was nonsense, in a sense. This process would continue through a few iterations until eventually the justice would step in and say, right, I need more evidence. And this is a fantastic way of finding out a little bit more about the case and the parties involved. Like with all of the other records mentioned so far, these tend to be stored at the National Archives. They're not as easy to discover though. Only the bills of complaints and the answers and replications and rejoinders are searchable by names of litigants. These next set of records are not. You have to go into the indexes at the National Archives and hope that the records survive. The first set relates to any questions that the Justice has asked the parties to answer. These questions, these interrogatories, will be posed to local people in the area, possibly older members of the community who could remember whether land had been passed from one family to another, or indeed remember anyone who was involved in the case going back a couple of generations perhaps. And these questions would then have answers, depositions, and they'd all be brought back into court. Sometimes those depositions would be taken under oath, in which case you would have affidavits. And the case would proceed with these sort of stop-start moments when the judge may well issue an order to get more evidence together. Sometimes it wasn't answering questions. They wanted to see actual evidence, particularly if there was a legal document being disputed. So you may well find that exhibits have been brought into court as well. This is where it gets really interesting for the genealogist, because you will often find pedigrees showing descent down different branches of the family, or wills or records of manorial courts or marriage agreements, all sorts of personal material brought in as evidence to see whether or not the case would go one way or another. So these have all been gathered together at the National Archives, and they provide a really rich history of the way our ancestors spent lots of time and money fighting over their inheritance or disputed land and other such issues that vexed us through the ages. You may well find that there is a final order or decree which sets out the justice's answer, whether it's one party or another. But this is actually quite rare. Most of the time, the case was brought to court to try and settle separately. So you may well find that a case just stops, and the chances are that the settlement was made by both parties under agreement, probably for payment of money, some other such thing. So don't be surprised if you don't always get a resolution to your case. But it's definitely worth having a look. These are fantastic records, and often they will supplement the family archive or perhaps show how your branch of the family got impoverished when they chased another part of the family unsuccessfully. So equity court records stored at the National Archives, fantastic resource.